Okay, you're live.
Hello, folks. I doubt if there's anyone listening at this point. It's 5 minutes to 6, but we have come out of executive session, and now the town attorney and the select board would like to talk to the buyer and their attorney to go over some questions that we have on the lease agreement, or the purchase and sale agreement.
Like a letter I was dealing with from a municipality, different municipality.
You're still here. Damn.
Testing our patience, aren't you, Ed?
We tried. We said, well, 6 o'clock they'll be gone, but we finished early. What can I
Well, we're the
say?
usual suspects, so we're...
The usual stuff, Jesus.
We just went out of executive session as a courtesy to you because you're still here.
Oh, that's nice.
We're
Thank you.
going to talk to you tonight, otherwise I would talk to you and follow up with you afterwards.
Sure, sounds good.
She's like you, she drove from the coast, so...
That's great.
Well, we had a good day for that. Usually it's blinding this time of year with from the coast. Okay. You want me to?
Yes, why don't you outline
All right. Okay.
our administrative concerns?
Okay. Yeah, we went through the agreements,
Okay.
and there are some mistakes in there for which I take responsibility. The purchase price should be $1
Okay.
daily, otherwise we have to pay transfer tax on the
Yeah.
100,000.
Definitely don't want to do it.
I just got confused because of all the different mistakes as to the $110,000 whatever, and I lost track of where it was going.
No worries. That's
All right.
okay.
So, I guess we have a basic question about title.
Yes.
Other than the issues involved in the Collins litigation, aren't you satisfied as to title? I understood that from your predecessor, that you are. So why do we need, can't we just have something in here reciting that you're satisfied as to title other than the Collins or the easement claim?
I see.
And, and the obligation of the town is just to avoid creating any new obligations. We don't have to negotiate this right now, I'm just laying it
Yeah.
out. 'Cause
Yeah,
you guys
thank
have to
you.
go off and decide
Yeah.
what you want to do about this thing. I'm just
Let me
gonna
make
get-
sure I understand. I'm so sorry.
I'd like to see a provision there
Yeah.
saying that you're satisfied as to title
Okay.
already,
Okay.
and the town's obligation with regard to title is merely to maintain it in its current state, not to allow any liens and stuff to arise. You're already responsible for mechanics liens and
Sure.
such. And you're in possession, so I don't see why,
Let me just make sure I understand though. So, are you talking in the context of how in the purchase and sale agreement, seller is obligated to convey marketable title, or are you talking about the contingency related to title review?
both.
Both. Okay.
And we wanted, as you saw in the draft there,
Yeah.
we wanted to be insurable. But
Yeah.
that's up to you. I mean,
Yeah.
as long as you say, in fact, now I think it makes more sense
Yeah.
to just say you've already done the title and you're satisfied with the
Yeah.
title. And that was my understanding of where Senator Hastings was on that.
Okay.
And you indicated you have your own title company who's
Yeah.
probably going to write the insurance. So, yeah, that it would be something along those lines.
I'll talk to my clients about that. I think I understand what you're saying. I mean, to be totally clear, David Hastings is still planning to issue the title insurance policy.
Of course, he wants the premium.
Right.
We're
So,
on public record.
sorry. I mean, who knows if that's his rationale, but I would not be surprised if it wasn't. But so I have emailed him asking for clarity as to the commitment. He sent me a list of title exceptions. We've had some back and forth on them, so we're trying to make progress with him. That had been our as in Drummond Woodson's arrangement when we took over representation of the Nelsons, that he would still be able to get the title premium. But I'll talk to him about his status there.
Okay, so that's the nature of what we'd like to see there. And that solves a number of other problems later on in the
Okay.
document.
Okay,
If we do that.
okay.
And as to the escrow agent, we're going to inquire of Bangor Savings as to what they're going to charge to act as
As
escrow
service?
agent.
Okay.
Or maybe, since we would like to have the cost of the escrow agent be the purchaser's cost, not the town's cost. Because we're trying to do this, the town's trying to do this without spending taxpayers' money
Sure.
on this. because
Yeah.
I think nobody in the town actually would support that.
Yeah,
So, I can't imagine the escrow agent's fee is gonna be big on this thing.
Sure.
They have a number of accounts with Bangor Savings.
okay.
And they will be getting the interest. It's a non-interest bearing account, so they would get the benefit of the interest. So they'd probably be willing to do it, Bangor Savings.
Okay,
But, gonna find out the cost. If you get somebody to do it cheaper,
yeah,
that's independent,
yeah,
the same kind of agreement,
Yeah.
where everybody has to indemnify
Yeah.
the escrow agent.
yeah.
That much risk the town is willing to take.
Okay, so let me, just to make sure that I understand, the town's preference is that the account still be held at Bangor Savings Bank?
But that'd be a true escrow account,
Okay.
where
Yep.
we don't control it.
Yep.
It's gonna
Yep.
be
A neutral third
a
party
neutral
that
third party
disperses,
that,
okay.
or puts it
Yep.
into fleet or whatever.
Yep, okay. Before we move on from that,
Sure.
or is now when we're gonna talk about the terms of the post-closing and escrow agreement, the qualified expenses, or are we gonna cover that? Is that next
Well,
on your
we're gonna
list?
go back
Okay,
to the language which was in the 2018 agreement as to what qualifies.
okay,
But it'll be anything that qualifies from the time that the amounts went into possession, anything they did
Okay.
during the lease term
okay,
will qualify for that.
okay,
And qualify for reimbursement once we've closed.
okay. And then, qualified expenses include costs related to the infrastructure and capital improvements? Let me see
Let me
what that
see.
language was. And when you say the original, back to the 2018 lease
Yeah,
option purchase?
2018.
Okay, so for expenses incurred by buyer for infrastructure improvements and structural repairs directly related to herein described property?
Yeah, they have to be permanent. Doesn't it talk about, I heard something more detailed when Ed read it.
where were you reading from? Ed, sorry.
He's Ed, that's
Chairman.
okay.
Sorry, Mr.
The
Chairman.
lease agreement.
The original
I
lease
know,
agreement.
I'm just trying to think which pile it's in.
Yeah,
Yeah, I
He's
don't
got
have it.
everybody else is David,
Yeah, that's
and-
right.
everybody else is David.
and everybody else except me is Bauer. So
Oh,
you
thank you, yes,
understand the
sorry
confusion.
about that.
That's all right.
When Jesse comes back, we can have a different
A little
configuration.
variety of
He's
names.
right behind you. Oh, the other.
Oh, the
Now,
other
that's
Jesse.
the other
Yeah,
Jesse.
the other Jesse.
That'll just add to the confusion.
Ah.
Oh, these guys by their last name, because
Yeah.
there's a couple of Jessies running around.
Exactly.
Yeah.
No, there's a couple of Jessies, a
Oh.
couple of Davids,
No.
a couple of Bowers.
Couple of them. There's costs related to TIF, is that what you were looking at, Mr. Chairman?
Right, terms 2A,
2A.
for expenses incurred by the buyer for infrastructure improvements and structural repairs directly related to the herein described property, seller reimburse up to the full amount of the cost of infrastructure improvements, structural repairs using funds from the account, escrow account in effect.
Okay, okay, got it.
We'll just pull that same language.
Same
out.
language? Okay. And just, so the board understands my rationale, our rationale, before you arrived, I had described how I had gotten the language for the other fees and costs that were, included in the language that I provided to David Lurie. And as actually from, post-closing and escrow agreement developed by Dan Flynn. I think Flint with David
Flint.
Hastings,
Yeah,
sorry,
Flint.
Flint with David Hastings. And I, all of this is catch up, trying to get to the place where people had been originally. So while we were in recess, I found the written notes, handwritten notes here from David Hastings, 100,000 escrow, can be used for closing costs, professional services, including architects and engineers, and structural repairs, can be used to pay invoices, and then again later, his handwritten notes. Prepare escrow, can pay HLA closing costs, escrow account, including legal fees. But
That's the first we've heard of that. I mean, when it came
Yeah.
through on your version of the.
totally fine.
Yeah.
Dan Flint was a selectman, but
Yeah.
then they spun him off to this revitalization effort back, 2017, whenever, way back when.
Yeah.
Yeah. Yeah, so it sounds like though that we're at a place where the language, the cost of infrastructure improvements and structural repairs, regardless of what had been sort of negotiated before, we'll
Mhm.
stick with cost of infrastructure improvements and structural repairs. And that is between the date of execution of the agreement, well, no, between the date of possession, which is July 1/19, and through and including closing, provided closing happens.
Yeah, but it's gonna be physical improvements, though, and it's gotta be physical, it's not going to include legal fees or engineering costs, things which are soft costs.
Sure.
It's gonna be hard costs.
Mowing the lawn, which there is none, but that's okay.
Yeah, okay, I'll have to, I hear that's what you're asking for, I'll have to talk to my client about that, because that's
Okay.
different than what we've discussed before.
Okay, that would have to be written in here.
Yep.
Right for us, yeah. All right, let's see, what else do we have here? That would be escrow. Okay. There were a lot of problems with dates.
Oh, yeah, let's talk about the dates.
Yeah, because nothing happens quickly.
And so to help flesh out my rationale for the environmental due diligence, it's like a complicated permutation of environmental law that we have to have the 180 days, less than 180 days between the phase 1 environmental site assessment and closing. If there's more than 180 days, then we don't get the benefit of Superfund liability protection. That's one of the drivers of our timeframe.
Now, this is a refiling, right?
Say that again?
We
Like an
thought-
update to the phase 1?
Yeah.
Yeah.
I was going to say, we thought that you had already done phase 1, and that's why you did.
No, the town, I think, did a phase 1 before we took possession.
Way back, yeah.
Way back.
That was before they were involved.
2012, probably,
Around the-
ballpark.
maybe before the
2007
VRAP.
even?
Yeah.
Exactly, because it
Yeah.
was a necessary precursor to the VRAP.
Yeah.
That's exactly right. So that, phase 1, we've spoken to the environmental law professionals at Drummond Wisdom. I'm not an environmental lawyer, but there are people there that do that. And they have helped me understand that because the standard, the ASTM standard has changed so much in the last 10 years, that we'll have to do an entirely new phase 1. We've started to get quotes from Ransom, who's the consulting firm that did it before. We think they'll be less expensive than other places and potentially a faster turnaround. But that is one of the sort of variables that we're gonna have to figure out how to align the timing, because if the Collins litigation extends closing, then we're gonna have the extra expense of a new phase 1 or an update to a phase 1 in order to get that time frame, capture that 180 days between the report and closing.
You're saying if we close sooner because that litigation ends at some point.
Yeah, close sooner is a risk, and then close later is a risk. It's like
What's the risk of closing later? other
the
than this?
environmental site assessment expires. We have to do
Or
another
it
one.
expires again?
Yeah, it expires again. It's like a
Jesus.
annuity plan for environmental consultant, basically, is how it's written under the most recent, I'm blanking on the term, but under the most recent regulations is what it is. So 180 days between the date of completion of the study and closing, no more than that. It's like it's got an expiration stamp.
Okay, we had no idea that was the constraint.
That's okay. I mean, I think a reasonable solution is to say for any of those dates, unless, like, these are the dates that we commit to unless extended by the Collins litigation, right? I mean, that's the only thing that would potentially draw it out.
Yeah, on the Collins litigation, the only thing that's gonna drag that out
Yeah.
is the requirement that it be final unappealable.
Right.
It seems to me you've had a chance to see the Collins litigation up front and personal,
Uh-huh.
and you know that eventually we're gonna win. No doubt about it in my mind, at least, you know, at the Superior Court level, we're gonna win. And then the question, you know, because we can't even get the motion heard, the second motion, or the first motion to make permanent the injunction. The judge won't hear that at the same time
Sure.
as the summary judgment motion
Yep.
next week. And because of that, we're gonna have to come back with a motion to make that permanent first, and then do the second one after, you know, whenever the Superior Court can get around to it.
Yep.
So that's gonna drag out some, because whenever you have to file a motion, that means you got another few months for that confirming motion to go through. I don't know if we should even bother with the confirming motion if in fact we can't close anyway, because the injunction, the preliminary injunction the town got, that won't be made permanent until a
Right.
later date
Right.
anyway. So we'll have to see whether there's any advantage to be got from doing the first one. It seems to me that your risk is very slight, you know, with the, you know, if we, once we get the permanent injunction of this, once we get the, the declaratory injunction, you know, it seems like that should be a slam dunk, because the court's already found that the line that they are using is not the line that's described in the easement,
Right.
among other things that are wrong. You know, it's, it seems like no matter how badly I screw up, we should win.
I'm sure.
And it's not, you get a new town attorney if I do, but seriously, you can never tell 100% what a judge is gonna do, but
Right.
we should have a decision on that relatively soon. And it seems to me that we can get that finalized and therefore unappealable, and meet your requirement without finalizing the injunction part of it. If you guys want to take over that case, you certainly could. And Drummond Woodson is fine, but, and we can, you know, authorize Drummond Woodson to appear for us in that litigation, and then you could be sure.
That's
But-
interesting.
But, all right.
I'll think about that.
Yeah, think
Put it on
about
my
it.
plan.
You know, they're probably not going to take on the expense because they know Mr. Collins and company, and the mortgagee hasn't been very helpful, to put
No.
it that way. But anyway.
Before we move on from that, though, let me just clarify, so, and I'm not a litigator by any stretch of the imagination, so this is outside my wheelhouse.
Everything's outside my wheelhouse. Go ahead.
But so there's 6 counts, right? There's the declaratory judgment claim, and then there's 5 counterclaims that the town made, if I'm recalling correctly.
Well, basically, we asked to enjoin them from dumping waste or sending waste onto the property,
Okay,
or into the property.
okay.
And we got a preliminary injunction on that. And there are 5 or 6 reasons why they should be enjoined from doing that. And anyway, we don't have to deal with that right now. what I'm suggesting is that we take out the word unappealable there, or the requirement that it be unappealable, get a judgment from the Superior Court, and you can talk to the litigators in your office. There's no way that the law court would set it aside, but
I hear you. I have that flagged and I've written a note down. What I'm trying to understand is whether that final non-appealable, whether appealable's in there or not, pertains to the, all of the counts that are subject to litigation. So 1, the deck action, and then 2 through 6, which are the counterclaims.
well,
But essentially, would the
You're
town
talking-
drop the counterclaims against Collins?
no, I expect to get a judgment on the counterclaims. There are 2 sets of counterclaims. One
Okay.
is the injunctive relief for nuisance and trespass and so forth, because they're not proceeding under their easement. The other counterclaim is to clear title.
I see. Okay.
That's, so it basically fall into 2 categories, and we've already got the injunction, and it should be made final, but, all right, well, we can talk about that some more.
Okay.
I'm just saying, we have a problem with extending out, but maybe that problem goes away if in fact the environmental stuff is going to push it out anyway. I mean,
I see what
at
you're
least
saying.
one of the
Okay.
people at the executive session had a big problem with the December 1, 2023.
What page are you on? Let me follow.
Well, it appears a couple of pages. The closing is in the marked up one, page 3. And that is, it first appears on page 3.
Oh, B,
Under-
Roman 2, the second deposit.
Right.
So was the feeling that that was too far out? What was the question?
Well, all the dates are too far out, but as I said, that might become necessary, given what you've now explained to us about the environmental thing, and just the idea that we'd be going out until December 31, December 1st, 2021. Although it's, or, you know, the final non-appealable judgment, those 2 things.
I see.
The 30 days could be any time the next 20 years. Given Mr. Collins. He's going to probably sue me for slander here. His lawyer is as difficult as he is, or more difficult. She is under the insane delusion, and has been from the beginning, that the town is trying to steal his rights, and the town wants a standing building, none of which is true. And that's what they've been operating from day one, and that's...
Not a good set of facts to
No,
operate under.
no. So,
Okay.
and they see conspiracy in everything
Oh, no.
the town has done, or would do. It appears again later, I guess in 5, the deed, closing, and inspections.
Okay.
Then we get, as I said, the environmental stuff which you apprised us of in terms of the timing under the Act, under the Clean Waters Act, is going to push us out anyway. So it's probably better not to have inconsistent dates of obligation, and let the environmental stuff control it, assuming we're satisfied that Ransom and you are acting in good faith. I think that we may have to give with regard to the dates that are in here, other than those which are environmental clearance driven.
Right. Yep.
Those look like the controlling dates now, so we'll probably have to figure out a way to get the other arbitrary dates out of there without, and we should be able to massage that to dealing with due diligence. As long as you're proceeding in due diligence in accordance with the environmental stuff, and I guess the town has relations with Ransom to begin with, so I assume that we all have confidence in them. But, we may need to have something in here talking about the town's access to ransom reports, and to inquire directly to Ransom if we have questions.
Sure, I'll talk to the client about that.
Okay, and you didn't have any problem with the mechanics lien?
No,
thing?
I think that makes sense, as long as it's mechanics liens,
you
that
create.
have arisen, during our period of possession.
That's right. Work that you consented to.
Yep.
And the town not
Yep.
sign off on.
Yep.
And if you come to the town and say, this is what we're going to do, then if the town should sign off on it, which I would advise them not to do, there'd be some responsibility, but,
There was a question, I don't know if you've gone by it or not, Dave, about the termination agreement,
Well, the termination, right?
inspection, and have until September to give us an answer.
Right.
yeah, well, again, your clients are in possession of the property, and we don't understand why, when they're already in possession, we should have to, why they can't do inspections now or whatever, other than the environmental ones that we talked about.
Yeah, that's the, September 1
Yeah.
is the driver, environmental is the driver for that.
But, I guess we're gonna have to go through this thing and make the environmental the driver for all of this stuff in terms of the timing,
Yeah.
and get out anything that would be inconsistent with the environmental
Mhm.
driver. In terms of the bill of sale,
Which page are you on?
well, I think we're at
Okay.
page 6 of the markup
Okay.
comparison.
Okay.
Number 9, closing, the seller's deliverables.
Yep.
There's gonna be no warranty, as is, where is, and so forth, as to equipment on the site and everything.
Okay.
Turning over. And there's a little problem with the oil tank disclosure thing, because the town was never in possession of this property, other than constructively.
So this
And
is the oil tank oil storage tank disclosure pursuant to
Yeah.
33 MRS?
Yeah, I
Yeah.
know that has to come,
Yeah.
but it's gonna have to have a disclaimer in it saying that we have no information on it.
I see what you're saying. There's
Yeah.
a standard form,
Mhm.
and I can't remember what the options are, but it's prescribed by statute, so.
I know it's
Yeah.
required by statute.
Yeah.
But I don't see how they can do that when the town has never been in possession. Maybe there's a way in the standard form where you can do that, you can disclaim any knowledge or whatever, and that you've done your own inspection. As part of your due diligence, to do the inspection for.
Uh-huh. I'm pretty sure that the standard form says seller is not aware, one of the options that you can choose. So we might not have to add, I hear what you're saying, we might not have to add additional
As long
disclaimer
as you
language.
understand that.
Yeah, I think that we'll be able to
Go
come up
through
with
the
something.
form, I'm sure. I'm sure this isn't the first time that's come up.
Yeah.
And I guess with regard to casualty and possession of
Yeah.
risk of loss,
Mhm.
you're in possession, and I don't see any need to put in something that would be very clear of all tenants and occupants except pursuant to the lease.
Well, assuming that the lease says that we have exclusive possession, then I agree with you, but at this point, there's no
We can put that in.
lease that's governing, so we need somehow to have assurances that
Absolutely.
there's exclusive possession.
Absolutely. Town doesn't want it.
Okay.
You can be really exclusive.
Okay. Sounds good. But in concept, I understand what you're asking for, and I think my client will be able to agree to that.
So, we talked about the title before.
Yeah. What page are you on? So I
Uh,
can- 10?
I'm on page 10 of the markup. It says, M, seller shall indemnify buyer for damages caused by the seller's acts or omissions during seller's ownership of the subject property. That needs to come out.
So the rationale for including that provision is that I understand, and this was all sort of the third person, that, so there is a declaration of environmental covenant on the property that was imposed on the property after the completion of the VRAP, right? And the declaration of environmental covenant says you won't disturb certain portions of the property. My understanding is that the town did disturb certain portions of the property, potentially in violation of the deck, and so my client doesn't want any liability associated with that.
When did they disturb it?
In investigation of the,
I think it was related to the Stanley
Oh,
the
Stanley.
proposed relocation of the septic system on this property.
And they
Remember
went
how
out
there
there
was
and
the-
did some soil evaluations.
Yeah, yeah. So if there's any kind of carve out that we can say explicitly, you know, this is, that the town will only indemnify as to liability created by virtue of the action on, you know, X day to X day in disturbance of the VRAP.
Hmm.
All right, we can work around that.
Yep.
We'll have to confirm
Didn't realize that.
happened.
It's just I mean, from our perspective, it's just an environmental concern.
Uh, And then indemnification language on the top of page 11 of the markup will come out.
I'll talk to my client.
Okay. And then your representations and warranties, that's again the
Mechanics.
mechanics lien and
Yep.
other liens that you put on the property.
That's fine.
Caused to be on the property.
Yep.
Okay. Default in the town's default, I guess we can live with the language about reasonable attorney's fees and costs, provided it's limited to willful default. If they just decide they don't like the Mounts Brothers anymore and decide not to close or whatever for that kind of a reason, but I think it needs to be tied to willful default if it's going to be, the town's going to accept risk.
So in order to get back in the language that you deleted, starting with "and buyer may obtain a refund of the entire deposit," on the end of the paragraph, we have to make it a willful default, is that what you're saying?
Well, I was actually talking about the specific performance provision, but I guess I don't know, we'd have to talk about whether, you see, this has to do with taxpayer risk.
Yeah.
And I guess we didn't discuss that, whether that would apply down here, that, to make that language acceptable.
procedure here is that ordinarily in a purchase and sale agreement, if seller defaults for any reason, we come to the table, we give you the cash, and then at the table you say, never mind, I don't want to convey to you. We gotta have some recourse. Ordinarily, it would be a refund of the deposit.
Well, the refunded deposit isn't the problem.
Oh,
It's the
okay.
language, and buyer shall recover from seller damages, including without limitation, reasonable costs, and so what that language.
Oh, so
means.
we can keep in refund of the entire
I
deposit.
think the
That's-
town can live with that. If the town
Yeah.
defaults, it's not
You
unreasonable.
mean we can't keep their money too? Then we could sell it to somebody else.
What do you think you are, South Portland? People like that? I'm dealing with them right now, and they're being unreasonable.
I don't know.
Hear that, everyone out there? Again, they're always unreasonable.
Okay, so your concern really is about seller damages, so buyer's reasonable out-of-pocket expenses. I see. Okay, we'll talk about that.
Yeah,
Okay.
that's the contingency that's proposed.
Okay.
And I think that's about it, other than casualty, would anybody want to rebuild if this destruction? But there would be an environmental consequence to destruction, because somebody's got to clean up the mess.
Yeah.
Or the government will get us. So we'll have to think about that.
Yep.
I don't know what to do with it right now. The town attempted to get insurance on the structures, but I don't know if it was understood that that was limited to the cost of cleaning up, because that's what the town's obligation would be, or whether the insurance company just will not insure above fair market value of the item. I don't know, because I wasn't involved in that discussion.
Okay.
So I don't know if there's any insurance that's available to either of us, either side here.
Huh.
If there is, and there's insurance proceeds from you, from your insurer, to the extent that it's attributable to the improvements, you get it. If you want to take the rest of the property along with it, that's fine, I think, with the town, which would like to get rid of this albatross.
I think that's fine. I'll talk with my client.
Anything else that I can cover with it?
I think you hit the hot spots.
Good job.
So you-
Mark, any questions?
Not this time.
Okay.
Covered pretty good.
was it worth waiting for?
Always.
Mm.
Yeah, very much so. Okay.
I'm gonna charge you rent for being in the hallway. It goes down the site.
It's funny.
Try to keep it light.
Well, we appreciate that. Okay, great. So in terms of procedural next steps, I will take the red line draft that you sent me and propose a version that I think accomplishes what you want, that is acceptable to my client.
Okay.
And I'll turn it back to you.
Okay.
And I'll do that both for the purchase agreement and the post-closing agreement.
The post-closing agreement, we just crossed out everything.
I know, I saw. Don't worry, I wasn't offended.
Look at it.
That's fine. I think I understand better what you're asking for at this point.
I guess you have not negotiated with a public entity that's stealing the taxpayers' money for a property that it doesn't want to take back.
It is a unique fact pattern. That's
It
exactly
certainly
right.
is.
Yeah.
Okay.
The other thing that I want to make sure that we do is have a lease executed at signing to govern the process between, or govern possession between signing of the purchase and sale agreement and closing.
Okay.
So the purchase and sale agreement draft that was circulated, you're ready to sign now? Awesome, okay.
Well, as long as
Yeah.
you
As long as he
go
says
along with
yes.
our attorney there, we're.
Yeah, right,
Well,
right. So
you
I'll
draft-
draft up the lease.
I mean, so this is a whole nother document
Yeah.
that we're gonna have to consider.
This is a pre-closing. document.
Yeah, I mean, the alternative
Trying to
is we
remember.
don't have a lease and we,
Well,
Have the
actually, there
purchase-
is, there is sort of a lease, there is sort of a lease.
well, the temporary, the TMLA, is that what you're thinking
Yes.
of? Yeah, exactly. You're exactly right, that it's still in process. The, problem with the TMLA is it doesn't say who pays for like repairs, maintenance, insurance, that we have exclusive possession, like all the things that would
Yeah.
normally, casualty, like what happens if the building burns down, all the things that would normally be contemplated in a lease. I mean, I guess what we could do, I totally don't want another document. I hear that you guys don't want that either.
Well,
Maybe
it's
we
called-
figure out how to build that into the purchase and sale
Let's call
agreement.
it a lease with an option to purchase.
I know, that's what the original purchase and sale agreement was called.
You don't wanna go back to that?
I don't. Just because I think that we've made a lot of progress. I mean, I like this agreement style more as a purchase and sale agreement because it sort of skips ahead over the like sort of melodrama of the last couple of years, right? Where we've been in this tenuous situation where we're leasing the property, we're not certain where we're gonna close. Now we wanna close, we just wanna get there. If we enter into the purchase and sale agreement, that is an obligation that we close, it's an obligation that we deliver. So maybe there doesn't need to be another document, maybe it's just that we,
It doesn't have to be an option to purchase, it can be a lease purchase.
yeah, or what if in the purchase and sale agreement, we just bulk up the lease provision and then record a notice of lease? Then our people.
A memorandum.
Exactly, yeah, then our people have cover, you guys have cover, like, the terms are publicly known, they're in the registry. Is that acceptable? Maybe you'll talk.
Sounds
to your
like it,
client.
yeah.
Yeah, you're in your council,
We'll all
yeah.
go to Danbury together.
Is that a thing?
Danbury.
Federal, federal,
But it's a very nice prison.
yes.
Oh, we're going to prison, okay, great. Not on my
Environmental
watch.
violations.
Not on my watch.
All right.
Okay, I think we're clear, thank you. Good,
Good.
thank you, everyone.
Thank you
Now,
very much.
Can I ask a silly question before you escape?
Of course.
When do you think you'll have this document prepared for our
For
esteemed
next
attorney?
review, well, it depends on how quickly I can get to it, probably,
I mean, just to, this, you know, I've waited 8 years. I mean, I
oh
don't,
jeez.
How long does it take to twist his arm?
yeah.
Well, it's not, no, it's more about my workload. I think that, probably just after Thanksgiving. Yeah, we'll do our best.
He doesn't look too happy with after Thanksgiving.
That's his neutral face.
Yeah.
We got a
Okay.
flight going out on the 10th, so.
You do?
Do I
We'll
have
get
to
back to
change
you.
it? Do I have to change it?
No.
My law school professor used to always say, "See you after turkey."
Yeah.
Yeah, no, we'll see what we can do to make it before then.
All right.
Oh, thank you very much.
Very good, thank you.
Thank you.
Appreciate it.
Thank
Thank
you.
you.
Thanks for putting up with us.
Yeah.
Thank you.
Sorry for keeping you waiting so long.
No, it's okay.
She doesn't care, she gets paid by the hour.
Well, it's a good conversation.
We had good conversations, I'm sure.
Bye.
Thank you, guys.
Bye.
Take
Yeah,
care.
good night.
I saw it.
Oh, you did? Okay. King was reelected.
Huh, he was?
Yeah. Sheriff King, they were
Yeah.
asking who.
Kane, I think he said Kane.
How, you don't know the votes
Yes, I
roughly?
do.
Well, anyways, okay,
He got
folks.
57,000, the other person got 43,000.
You're still not closing the meeting, Ed.
I know it. Oh, right, well, I'm
Bang
just
the
sort of,
gavel.
I was reaching for the gavel because I wanted to shine one end of it.
We have to
Okay.
go into executive
Yeah.
session again.
Right, so now, folks, we have anybody there, maybe my wife, who knows? Maybe Leslie, David,
Nah,
is
she
she?
doesn't listen.
No, she doesn't listen.
He gets
All
my.
right, so we're gonna go back into executive session, folks, for
David has to turn this off.
Yeah.
one more time, and then we will be closing the meeting.
And the motion is?
Oh, I thought we already,
Going to-
Well, that was for,
No, there's a second.
yeah, there's a second
here,
one.
David, you can
It's
just-
on the agenda.
Consultation with attorney
I-
relative to
I
pending-
put both our names down because I thought we
Okay.
voted on it.
Okay, well,
Here.
I'll make a motion that we go into executive session for consultation with our attorney regarding Reed Lane
litigation.
litigation. All in favor? Or any comments? All in favor? It's gotta be 60%.
I know, so if I say no, I go home, right?
That's right.
Oh, no, all right.
So,
Okay. All right, so we are going into executive session. We are not going to start the video up when we come out of executive session because the only thing we will do is close the meeting. So, thank you, folks.